Have you ever been tempted by a deal that just seemed, well, too good to be true? Maybe that designer handbag for a fraction of the price or, those premium electronics at a crazy low cost.
It happens all the time. That pull of a bargain is strong.
Exactly. But lurking beneath the surface of many of those deals are hidden risks and honestly a whole world of illicit trade. Today on The Deep Dive, we're plunging into a really crucial piece of South African legislation that tackles this head-on. The Counterfeit Goods Act 37 of 1997. Our mission here is simple. We want to unpack this important act, make it crystal clear, engaging for you. Doesn't matter if you're just curious about consumer protection and intellectual property, or maybe you're a law student needing to grasp the nuances. We'll look at its core purpose, what it actually bans, how it's enforced, and the real-world consequences.
And it's a piece of legislation with a history, but still very much relevant. It kicked in on January 1st, 1998, assented to in late 97, had its last amendment back in 2001. And just for the record, we checked its current status as of March 28, 2025. So yeah, we're looking at the law as it stands today.
Okay, that gives us the timeline. So let's start at the beginning. What's the fundamental purpose of this act? Why was it needed?
Well, at its core, the act was brought in to create some really robust measures against the trade in fake goods. Its main aim is sort of twofold. First, it's about protecting the original creators, the owners of intellectual property rights. We're talking trademarks, copyright, that kind of thing, protecting them from having their work unlawfully copied. And second, just as importantly, it's designed to stop these counterfeit goods from getting into legitimate shops and markets, essentially shielding the public from deceptive and often, let's be honest, low quality or even dangerous fakes.
Okay.
So it's a dual protection for the IP owners and for you as a consumer.
Right, protecting both sides. Okay, let's unpack this a bit more. Before we get into the specifics of what's banned, what does counterfeiting actually mean according to this act? What are the key definitions we need to get our heads around, the sort of building blocks?
Absolutely. Definitions are crucial here. First up is intellectual property right. The act is specific. It covers rights under the Trademarks Act 93, the Copyright Act 78, and even certain marks under the older Merchandise Marks Act from 1941.
Okay, so it's pretty broad then, not just logos.
Exactly. It includes unique product designs, original music, books, software, a wide range. Then there's counterfeiting itself. The act basically defines it in three main ways. One, manufacturing goods that are substantially identical to protected goods without permission. And this is key. This act must infringe an IP right.
Okay.
Two, applying the protected design or mark, or something the act called a colorable imitation, to goods.
A colorable imitation, like something deliberately close.
Precisely. Think Adibus instead of Adidas, designed to confuse.
No.
The critical thing here is it causes confusion and it infringes the IP right.
Right. Still needs that infringement.
Yes. And thirdly, making or applying a specific mark that's prohibited under the Merchandise Marks Act without authority, again, provided it infringes an IP right. The common thread, the absolute must-have for counterfeiting under this act, is that the action has to have infringed the intellectual property right. It's not just about looking similar, it's a legal violation.
Okay, that clarifies the act of counterfeiting. What about the goods themselves?
Right, so counterfeit goods are simply the products resulting from that counterfeiting. And interestingly, the definition also includes any means used for purposes of counterfeiting.
Ah, so like the molds or printing plates.
Exactly, not just the fake shoes, but the tools used to make them. Then you have protected goods. Those are the genuine articles, the real deal, goods made with the IP owner's permission. The Act also defines an act of dealing in counterfeit goods, which we'll get into. And finally, an inspector is defined usually a police official, sergeant rank or higher, or sometimes customs officials. These definitions set the stage.
Okay, foundationally. So with that in place, what does this mean practically? What specific actions involving these goods does the Act outlaw? And crucially, when does it cross the line into being an actual crime?
The Act is pretty comprehensive here. Section 2(1) lists what you can't do with goods that are confirmed counterfeits. Essentially, you can't possess or control them for business purposes, no manufacturing, producing, or making them, unless, and this is an interesting little carve-out, it's purely for your own private and domestic use.
Private and domestic use. So making one fake T-shirt for yourself wouldn't be prohibited dealing.
The act of making it for yourself isn't prohibited under the section dealing with commercial acts, but the item itself is still counterfeit, and other issues might arise. But commercially, you absolutely cannot sell them, hire them out, barter, exchange, or even offer to do so. You can't exhibit them in public for trade, you can't distribute them for trade, or even distribute them non-commercially if it prejudices the IP owner.
Okay.
And importing them into or through South Africa or exporting them is also banned. Again, that private use exception applies to import-export too, and basically any other way of disposing of them in the course of trade is out.
So a very broad range of commercial activities. When does doing one of these things become an actual offense?
Right, that's Section 2 too. It becomes a crime if the person doing the prohibited act knew or had reason to suspect the goods were counterfeit. Or, and this is the really important bit for anyone in business, even small sellers, if the person failed to take all reasonable steps to avoid doing the prohibited act.
The negligence part.
Exactly. You can't just turn a blind eye or plead ignorance if you didn't do your homework. The act puts the responsibility on you to check authenticity.
That failed to take all reasonable steps.
Yeah.
That's huge. It widens it considerably, doesn't it?
It really does. It's not just about the deliberate fraudsters. It catches negligent actors too.
So, given this wide scope, how do the authorities actually enforce this? How do they catch the goods and the people involved? What are the mechanisms?
Enforcement is pretty robust, actually. It often starts with the IP owner laying a complaint. Anyone with a legitimate interest, the brand owner, a licensee, an importer who reasonably suspects an offense, can report it to an inspector. They need to provide some basic evidence, prima facie evidence, that the goods are fakes and show their connection to the genuine IP.
And the inspector has to act.
If they're reasonably satisfied the complaint is valid and the suspicion is reasonable, yes, they must take steps. But importantly, inspectors can also act on their own initiative if they have reasonable grounds to suspect counterfeiting. They don't have to wait for a complaint.
Okay. And what powers do these inspectors have?
They have quite broad powers. They can enter any place, premises, vehicle, inspect goods, seize suspected fakes, collect evidence, conduct searches, even searches of people. Generally, though, these actions require a warrant from a judge or magistrate.
Standard procedure. Makes sense.
Right. Issued under oath specifies what's being looked for, usually executed during the day, respecting privacy and decency.
But are there times they can act without a warrant? Situations where speed is critical.
Yes, there are exceptions. If they get consent from the person in charge, they can proceed. Or, if the inspector reasonably believes a warrant would be issued, but the delay would likely mean evidence gets destroyed or disappears.
The hot pursuit kind of idea.
Sort of, but there's a crucial limit. They cannot enter and search a private home without a warrant, no matter what.
Protection for private dwellings.
Absolutely. And any search or seizure done without a warrant needs to be confirmed by a magistrate or high court judge within 10 court days.
Confirmation after the fact.
Yes. And if it's not confirmed, the goods have to be returned and any damage must be rectified. It's a significant safeguard.
That is a strong check on power.
It is. Also, during a search, inspectors can be assisted by the complainant or other experts to help identify the suspected fakes.
So after they seize goods, what happens then? What are the inspectors' duties?
They have specific duties following seizure. They must immediately seal the goods, identify them properly, and make a detailed inventory in quadruplicate, actually. Copies go to the person they seized from and the complainant. Then the goods are moved as soon as possible to a designated secure place called a counterfeit goods depot.
A depot, like a special warehouse.
Essentially, yes, for safe storage. If the goods are too big or impractical to move, the place of seizure can be declared a temporary depot. Then the inspector has to notify everyone involved, the suspect, the complainant, in writing about the seizure and the depot address. And they specifically tell the complainant they have 3 working days to lay a formal criminal charge.
Only 3 days. That seems quick.
It puts the onus on the complainant to act swiftly if they want criminal proceedings.
And what about accessing these seized goods? Can the parties inspect them?
Yes, the Act covers storage and access. The goods stay in the depot until a court order or the inspector directs otherwise. All parties involved can inspect them during office hours. They can even request testing or analysis, though there are rules around getting approval for that.
And when are the goods released? What triggers that?
There are several triggers for release. If the complainant doesn't lay that criminal charge within the 3 days, the goods must be released, generally. Also, if the state doesn't signal intent to prosecute within 10 working days, or if the IP owner doesn't signal intent for civil action within 10 working days. Basically, if legal action isn't pursued relatively quickly after seizure, the goods are supposed to be returned, or, of course, if a court orders their release.
It really strikes me hearing this, the balance the Act tries to achieve. The need for swift action against fakes, but also protecting individual rights, like that judicial confirmation for warrantless searches or the right to have lawyers involved. It's quite intricate.
It really is. And it's not just police inspectors. Customs authorities play a big role too, especially at the borders. An IP owner can apply to the Commissioner for Customs and Excise to intercept and seize suspected counterfeit goods being imported.
Proactive action at the border.
Exactly. The IP owner needs to provide a sample of their genuine product and details of their IP right. If the commissioner is satisfied on a prima facie basis, the application's granted. But, and this is important, the IP owner must provide financial security.
Security. Why?
To cover potential liability for customs if the seizure turns out to be wrong, and to cover the costs of detaining the goods. And the Act also explicitly states that customs isn't liable if they fail to spot fakes, or if they accidentally release them, or for actions taken in good faith. It sets clear boundaries on their responsibility.
Okay, so that covers identification, seizure, storage. Now let's move into the courtroom. Beyond the initial enforcement, what happens legally? What kind of court actions and consequences does the Act lay out?
Well, there are significant judicial aspects. IP owners can launch civil proceedings for search and attachment. This is sometimes called an Anton Pillar order, although the Act has its own specific procedure. It allows the IP owner to go to court, initially ex parte, meaning without notifying the other side.
Without telling the suspected counterfeiter.
Right, initially. To get an order to search premises and seize documents, records, and suspected counterfeit goods. The whole point is to preserve evidence, especially if there's a real fear it might be destroyed or hidden if notice was given.
A powerful tool.
Very. But there are conditions. You need a prima facie case of infringement and show that evidence discovery would likely be frustrated otherwise. When the order is executed, the respondent's attorney can be present if they can get there quickly. The applicant's attorney must go with the sheriff, explain the order, and file a report afterwards. The court can also require the IP owner applying for the order to provide financial security to the respondent, just in case the claim fails later.
Protection for the person being searched, then.
Yes. And on that note, if the IP owner's infringement claim is ultimately dismissed by the court may order them to pay compensation for any harm or prejudice caused by that search and seizure.
So there's a potential cost if you get it wrong.
Definitely. Beyond those specific search orders, courts can make various other orders under Section 10. They can order counterfeit goods to be delivered up to the IP owner or released to someone else. If goods seized turn out not to be counterfeit, the court can order the complainant to pay damages and costs to the person they were seized from.
Fair enough.
And a really crucial point. If goods are found to be counterfeit, especially those that are confusingly similar or use prohibited marks, the court generally cannot allow them back into commerce just by removing the fake logo or mark.
So you can't just debrand fakes and sell them?
Not usually. Nor can imported fakes just be exported again without alteration, unless the court finds good cause shown, a high bar. This stops the goods re-entering the market easily. Courts can also order an accused person or a defendant in a civil case to disclose their sources, where they got the fakes, who else is involved in the supply chain.
That could really help break up counterfeiting rings.
That's the idea. And the Act also touches on evidence and presumptions. Inspector statements, evidence they collect, can be used in court. And there's an interesting presumption related to dealing. If someone who normally deals in genuine goods is caught with more suspected fakes than seems reasonable for personal use.
Like a shopkeeper with boxes of fakes in the back.
Exactly. It's presumed in civil cases, until they prove otherwise, that they had those goods for dealing. This applies similarly in criminal cases, unless they offer credible rebuttal evidence. It shifts the burden slightly.
A powerful presumption indeed. Okay, this brings us to the sharp end. The actual penalties. What happens if you're convicted under this act? And who bears the liability if things go wrong during enforcement?
Right, the penalties are significant. For the main offense of dealing in counterfeit goods, defined in Section 2.2, a first conviction carries a fine of up to R$5,000 per article or item, or imprisonment for up to 3 years, or both.
Per item. That could get expensive fast.
Very fast.
Yeah.
And for a second or subsequent conviction, it jumps to a fine of up to R$10,000 per item, or up to 5 years in jail, or both. The minister also has the power to increase these fine amounts over time. Crucially, when sentencing, the court must consider any risk the fake goods pose to human or animal life, health, safety, or property.
So dangerous fakes might lead to harsher sentences.
That's the clear implication. But there is potential mitigation. If the convicted person fully and truthfully discloses their source, identifies others in the supply chain, reveals distribution methods that can reduce their sentence.
An incentive to cooperate.
Precisely. There are also penalties for miscellaneous offenses under Section 18, things like obstructing an inspector, tampering with seized goods, giving false information. Those carry a fine or up to 6 months imprisonment.
And after a conviction, what can the court order regarding the goods themselves?
The court can order the counterfeit goods to be forfeited to the state or order their destruction. This includes packaging and any tool specifically used for the counterfeiting. And here's something quite surprising and actually beneficial for consumers who get duped.
Oh, what that?
If an aggrieved person, someone who bought counterfeit goods, provides proof of purchase and cooperated fully with the prosecution, the court can order the convicted seller to pay that person compensation equivalent to 3 times the price they paid for the fake item.
3 times the price.
Yes. It's a significant remedy for the consumer, turning victims into potential enforcers in a way. It applies to goods acquired for value, not just purchase, too.
That's a real incentive for consumers to report fakes. Okay, what about liability if mistakes are made during enforcement? If goods are wrongly seized?
The Act addresses liability for damage or loss. Generally, the complainant, the IP owner or agent who initiated the action, is liable if goods are wrongfully seized, removed, or detained, causing damage.
So the responsibility falls mainly on the person who made the complaint.
Primarily, yes. The state, the inspector, or the depot manager are only liable if they were grossly negligent or acted in bad faith during the process. There's a higher threshold for state liability. And finally, it's worth remembering that this act operates alongside other laws. It doesn't replace civil or criminal liability for IP infringement under, say, the Copyright Act or Trademarks Act. It adds another layer.
Well, we have certainly taken a deep dive today. From that initial lure of a bargain to the really complex legal framework designed to combat fakes, it's clear the Counterfeit Goods Act of 1997 is a serious piece of legislation. It tackles the problem from multiple angles, protecting creators, protecting the public.
Absolutely. If you zoom out, you see a comprehensive system. It reflects a strong commitment against illicit trade. It doesn't just criminalize dealing in fakes. It gives authorities and IP owners real teeth for enforcement. But as we've seen, it also weaves in those crucial checks and balances to protect the rights of the accused. It's a complex balancing act, but a vital one.
So maybe the next time you see one of those too good to be true deals, you'll remember this complex legal machinery working behind the scenes. It makes you think, doesn't it? What really stands out to you about that balance between strong enforcement and protecting individual rights in this act? And how might knowing this change how you look at everyday goods, knowing the effort that goes into protecting authenticity? We definitely encourage you to explore further. Maybe look up those other acts we mentioned, the Trademarks Act, Copyright Act, or search for recent news stories about counterfeit busts. See this act in action.